why would somebody want to register under any of those acts, and how does one proceed?
For many years, a lot of associations registered their association under the Karnataka Society Registration Act. But I don't have the authority or the power to do anything.
Hi Sneha.
Hi, good morning.
Welcome. We today are going to talk about predominantly with Resident Welfare Association and laws related to that. If you have any questions that you would like answered, please put it in the comment section and we will also come back and answer those questions. There has been a lot of discussion about the various acts that are currently present in Karnataka regarding the Residents Welfare Association. Do you want to take our audience through some of these laws that are present? What are the pros and cons, if you can call them that, and why would somebody want to register under any of those acts, and how does one proceed?
Right. So I think I will start off by telling the audience what they should not be doing. As of today, registration under Karnataka Society Registration Act, which is popularly called the 1960 Act, you cannot register associations under that. In fact, the law never provided registration of associations under the Karnataka Society Registration Act, because the objectives of the Act was never designed for an apartment association at all. There is no concept of collecting any maintenance per se under the Act. But I think because of the ease of the process of registration, for many years, a lot of associations registered their association under the Karnataka Society Registration Act, which of late the courts have come down upon and made it very clear, saying that you cannot register an apartment association under Karnataka Society Registration Act, because the objects of the Act is for some other purpose altogether. You cannot collect maintenance under this Act. So any association that is registered under the Karnataka Society Registration Act technically or rather legally cannot collect maintenance. And the purpose of registering an association or an apartment association is to collect maintenance and to maintain common areas.
One of the things is to collect maintenance, etc. That it
Right.
is a large part of it. What happens to those associations that have used this particular act to register?
Ideally, they should today consider registering their association under other acts that are available, which I will shortly talk upon. So they have to, in future, sort of move or transition to these new acts, or rather the acts that existed for a very long time. I feel like that's the only way. There's no other option.
We've had a scenario, actually one of our clients, we won't take the name, where one set of residents have registered under the Societies Act. The other set of residents say, no, this is not the right thing to do. We want to register under the Apartment Associations Ownership Act. And that's what they've done. And they have approached us to do a RWA photo audit. That is the Resident Welfare Association Handover Takeover Audit. What happens in this scenario? I know we're not asking you for legal advice, but what is the way forward for a situation like this? Because then you have two different parties within a society who are not only fighting amongst themselves, but legally also, what are the ramifications?
Right. So if you are registered under the Karnataka Society Registration Act, and if you're trying to collect maintenance, a resident today can say, I'm not going to pay. There's nothing you can do about it.
Okay.
You can't go file a case. You can't go to the registrar and say, I need to collect. So there is no way for you in law to claim that maintenance amount. So then the purpose of forming this, you may have an association, but if you're unable to enforce the fact of payment of maintenance, then I don't see what is the purpose of that registration being there.
Okay.
So I'm not sure about the situation that you spoke about, but in a scenario like that, if an association has registered under the Society Registration Act, they can't do anything about it. People who don't want to pay can opt not to pay. But how do you come together at the end of the day to collectively form an association?
Exactly. So this is the same thing that we were discussing with them. say there are 100 residents and they say, no, you formed under both these acts, I will choose to say that you're under the Cooperative Societies Act, I will not pay maintenance. Right? That is a kind of a stickish, I don't know, probably the law, the courts will have to decide on that.
So, now let me talk about the other legislations that are there under which you can actually form an association. Maybe then there'll be a bit
more clarity.
Yeah.
Okay.
So there are associations, resident welfare associations that can be formed under the Karnataka Co-operative Societies Act, which is a 1959 Act. Even though fundamentally, if you read the Act, nowhere does it say you can register an apartment association per se, but the Act allows you to register for any purpose wherein maintenance can be collected.
This is the
Karnataka Co-operative Societies Act 1959.
The previous one was?
Karnataka Society Registration Act 1960.
Okay.
Which
so the 59 one is
59
possible?
is possible.
60 is not.
60 is not.
Yeah.
So that can still be done. Now, why do a lot of people not opt for registering associations under Cooperative Societies Act? Extremely time consuming.
Okay.
Cooperative Societies Act has not been in great demand with respect to apartment associations because they're very time consuming. Lot of procedures. So that is why it's avoided.
It's very heavy.
It's heavy.
Okay.
And also time consuming. That's why people avoid it. But I think as we start using and registering under the Cooperative Societies Act, things may start easing out because I feel like the department is also learning. They've not faced these kind of volumes. So now with so many apartments coming up and people opting to form associations under Cooperative Societies Act, it should start getting easy is my personal view, but may not be the case either. Then the other act where people are registering association is the Karnataka Apartment Ownership Act 1972. It's been there since 1972. But primarily people have not again opted, a lot of apartments have not opted to register under the 72 Act because there is a bit of ambiguity in the Act. There is, so the way acts are perceived is to see who do I register it before.
Okay.
Now, if you look at the Cooperative Societies Act and the Society Registration Act, there are authorities before whom you go and register. Under the Societies Registration Act, there is the Registrar of Society. Under the Cooperative Societies Act, you have the Registrar of Cooperative Societies. Now, under the Karnataka Apartment Ownership Act, the competent authority has been nominated to be the Cooperative Society, Registrar of Cooperative Society. But as such, he says, I'm not empowered, or there are no rules that there are no rules formed saying these are my rights, so these are my obligations, and this is what I'm supposed to do in the Act. So he says, I may have been named,
but I don't have the
authority. I don't have the authority or the power to do anything. So this sort of left everybody in a bit of confusion, saying then how do I do it? If I don't have an authority, is this act even legal? And unfortunately, the Karnataka Apartment Ownership Act does not consider the association to be a juristic person like the Societies Act and the Cooperative Societies Act. What does that mean? If you're a juristic person, by law, you have a right to sue and right to be sued.
Okay.
Just like companies. Companies have a right to sue because they're juristic persons under law. If you are an association registered under the Cooperative Societies Act or the Society Registration Act, you're a juristic person. So you have a right to sue and right to be sued. The Act allows you to be a juristic person by stating it in the Act. But the Karnataka Apartment Ownership Act does not recognize associations registered under it to be a juristic person.
So it doesn't specifically state that it can be or cannot be
If it
sued.
doesn't specifically state, it is not.
Okay.
That's the presumption we have to draw.
Okay.
So that is one of the reasons why not many people have gone into the KAOA 1972. Now, this is not a blocker, but I'm just stating, my view in terms of why people have not opted for these laws despite them being there. So lack of clarity is a very big issue. But there were still many developers who registered an association under KAOA. Another problem it's not a problem, but another issue with KAOA is that every apartment owner has to be a signatory to the deed of declaration. So let's see.
It should be 100%.
100%. So if there are 1,000 apartments, 1,000 signatures have to be there in the DOD.
Okay. If it is not?
If it is not, you can't register. Even if you registered an association without all owners agreeing to it, then it's not legal. under the Act.
So okay. So you're saying that if there is a society with 1,000, 2,000, 3,000 units, and they decide to register under the KAOA 1972 Act, then the deed of declaration has to be signed by every single owner of those 1,000 units or 2,000 units.
Correct.
Okay.
So how are builders dealing with this? Before selling the apartment, when the ownership is with the landowners and the developer, at that point they prepare a DOD.
Okay.
So then you're eliminating this whole problem because it is at the time of execution of the DOD who is the owner.
So
that's what
just
determines.
you get two signatories.
So they are the owners. So at that point they register the DOD. So the problem of this whole, requiring 1,000, 2,000 signatures is solved.
Okay. If somebody does question that later on, saying that no, I have bought this from the builder, but I don't agree to this, then they have no recourse to it.
No. So the Act says that apartments, it's transferable, heritable, etc. So every time a new owner comes in, the owner doesn't have an option because it's already been submitted.
Okay.
Your apartment is already submitted to the Karnataka Apartment Ownership Act. So again, if you have to withdraw, everybody have to come together to withdraw. One person per se cannot come and withdraw. That's how the Act is structured.
Okay. Got it.
So that's one of the reasons why builders register a deed of declaration, so that you can avoid this whole every single owner has to come forward and sign.
What exactly does the deed of declaration do? What is it for? If you can just give us a brief idea, and then we can go to the next.
It's a document where you're coming together and saying that this is my apartment. Let's say your apartment is constructed over 5 acres. You're saying this 5 acres of land I'm submitting to the Karnataka Apartment Ownership Act to be, so that this 5 acres is governed, or I can use all the rights and obligations that the Act has, given me. I will use that, and I'm submitting this property of mine. I'm talking about collective, not individual, where everyone's coming together and saying we are submitting our entire property to this Act in order to be governed under this Act.
So
it's a choice.
Yeah, so the deed of declaration is a choice, but only under the KAOA.
Correct.
Okay.
There's a PIL that's filed before the Karnataka High Court. Wait for the legislation to come out, or wait for the court judgment to come out. You can also register resident welfare associations as a Section 8 company, a non-profit organization. You can also register under the Partnership Act.